here, so you don't need to put in your name. Yeah. Yes, so we're just waiting for Ramona. As soon as she comes in, we'll start. If something changes, I'll let you know.
Good morning. Please stand for the national anthem of the Republic of Trinidad and Tobago. Thank you. You can certainly have your seats. Her Excellency, Mrs. Rima Carmona, First Lady of the Republic of Trinidad and Tobago, the Honorable Chief Justice of the Republic of Trinidad and Tobago, Mr. Justice Ivor Archie, the Attorney General of Trinidad and Tobago, the Honorable Faris Alwari, Her Excellency Carla Hogan Rufields, High Commissioner of Canada to Trinidad and Tobago, the Honorable Madam Justice Maureen Rajnath Lee, Judge of the Caribbean Court of Justice and Chair of the Sexual Offences Advisory Committee, Honorable Justices of Appeal, Honorable Judges, Masters of the Supreme Court of Trinidad and Tobago, and Magistrates, Councillor Dr. Agatha Carrington, Secretary of Health, Wellness and Family Development, Tobago House of Assembly, Chairman of Commissions, Mr. Stephen Williams, Acting Commissioner of Police, Dr. Penny Reedy, Director of the JURIST Project, Ms. Marian Taylor, Rape Crisis Society, members of the media, and of course, other distinguished ladies and gentlemen. Good morning. Hello and welcome. I'm Renee Cummings, and this is the launch of the Model Guidelines for Sexual Offense Cases in the Caribbean region. It gives me great pleasure, and it's certainly quite an honor, to introduce our most distinguished head table. And let me begin on my far left with Ms. Marian Taylor of the Rape Crisis Society, Dr. Penny Reedy, Director of the JURIST Project, Her Excellency Carla Hogan Rufields, the High Commissioner to Trinidad and Tobago of Canada, Honorable Mr. Justice Ivor Archie, the Chief Justice of Trinidad and Tobago, Honorable Faris Alwari, the Attorney General and Minister of Justice and Legal Affairs, and Honorable Madam Justice Maureen Rajnath Lee, Judge of the Caribbean Court of Justice and Chair of the Sexual Offences Committee. And as we begin with our opening remarks by Dr. Penny Reedy, who is going to provide an overview of the project and the work being done in the region, including in the area of sexual offences. Dr. Reedy.
Thank you, Dr. Cummings. And if I could acknowledge that protocol has been established. A warm welcome to all of you. Good morning, and thank you for attending today's important event. Today's launch is a milestone in the life of the JURIST project. The guidelines are the result of many months of hard work, dedication, and commitment on the part of the JURIST team, the advisory committee to the JURIST project, and stakeholders in the justice sector to improve the management of sexual offense cases and the treatment of survivors of sexual offenses throughout the Caribbean. You will certainly hear more about the blood, sweat, and tears that went into the development of these guidelines in a few minutes. The guidelines are both groundbreaking for the region, and they are timely, given global headlines on allegations of sexual harassment and assault in the entertainment sector, in politics, in the media, and in other sectors. But my role here this morning is to tell you a little bit about the JURIST project, and if I can situate the JURIST project in the region. It's a multi-year project. It's funded under a $19 million contribution by Global Affairs Canada. It's being executed by the Caribbean Court of Justice on behalf of the Conference of Heads of Judiciary of CARICOM. The Caribbean Court of Justice and other regional partners are also contributing approximately 4 million Canadian dollars to the project. So what is the project doing? Well, it's working with judiciaries in the Caribbean to support their own efforts to improve court administration and strengthen the ability of the courts and the judiciary to resolve cases efficiently and fairly. Our aim is to modernize and strengthen court systems, processes, and services, and to equip judicial officers and court staff with the skills and competencies necessary to deliver justice in a fair, predictable, efficient, and timely manner. The ultimate goal of the JURIST project is to develop a regional judicial system that is more responsive to the needs of women, men, youth, and the poor. We have a number of wide-ranging initiatives currently underway in Antigua, Barbados, Belize, Guyana, and Jamaica. But I want to focus for a few minutes on the work that we're doing in the area of gender equality. It is a cross-cutting theme in the JURIST project. This means that every initiative we consider must be viewed through a gender lens. And this in turn means that we must integrate gender equality throughout each step of the court process, from the filing of cases to case disposition. It is my view in the time that I've been here as a director that the work we do in this area will be key in determining whether the JURIST project is a successful regional project. We have made great strides thus far. Today you'll hear a number of them. We've completed a number of initiatives, and I'd like to just list them for you. Of course, there are the guidelines for sexual offense cases that we are here to launch today. There's also the development of a survivors' rights charter. Gender equality protocols for magistrates and judges have been prepared for Barbados, Trinidad and Tobago, Jamaica, Guyana, and Belize. We've undertaken gender equality and access to justice training for staff at the Caribbean Court of Justice. We have conducted a sexual offenses baseline study in 5 CARICOM member states. And we have undertaken a gender and judicial decision-making survey that was administered to judicial officers in 14 CARICOM member states. If you'd indulge me for just a few more minutes, I would be remiss if I didn't acknowledge the other important initiatives that are in progress or have recently been completed. And these include a disaster recovery and business continuity plan for the Barbados High Court, with a regional workshop planned for all participating judiciaries this year, training on court administration and adjudication that is gender responsive and customer focused, gender and harassment policies developed for the Caribbean Court of Justice, an operational review of the High Court Registry in Barbados with plans to conduct a similar review in at least 3 other judiciaries, re-engineering of business processes and the introduction of technology to eliminate backlogs, to improve case management, and to undertake training for a more efficient administration of justice. We've been supporting courts to develop tools to deliver public education programs and to measure customer feedback. We've established a knowledge management system to house all information assets of the project, as well as those of other justice reform initiatives in the region and globally. And of course, we've established specialized courts, and we will continue to do that. Finally, let me just say a word about sustainability. It's key to this project. Once the project ends, we want to ensure that all of the judicial reforms and the strengthening of administration of justice continues after we leave. And in order to deal with sustainability, what we have embarked on is an undertaking to make sure that the results of all of our completed initiatives are shared with other participating countries, that best practices are identified and shared, and we will encourage the implementation of similar initiatives in other judiciaries for the duration of the project. In closing, let me just say I would invite you to go to our website where you can get more detail on a number of the initiatives that have either been completed or are in the process of being implemented. And let me reiterate the importance of today's launch of the sexual offense guidelines. They are, as I say, groundbreaking. You'll hear much more about the guidelines over the course of this morning's launch. And I do want to thank each of you for participating in today's event. Thank you so much.
Dr. Reedy, thank you. And now to provide an overview of the guidelines, look at the objectives, why they were developed, the target audiences, and expected outcomes, Her Excellency Carla Hogan-Rufields, High Commissioner of Canada to Trinidad and Tobago.
Thank you. Thank you very much. Her Excellency, Mrs. Carmona, First Lady of the Republic of Trinidad and Tobago, the Honorable Chief Justice of the Republic of Trinidad and Tobago, Mr. Justice Ivor Archie, the Attorney General of Trinidad and Tobago, the Honorable Faris Al-Rawi, other members of the head table, honored guests and stakeholders, members of the media, ladies and gentlemen, please allow me to say that all protocols are observed. And good morning. I am extremely pleased to be here this morning to bring you remarks on behalf of the Government of Canada. I'm very proud of the work that this project has been doing and the connections and the hard work that's been going into this, into the development of these guidelines over the course of the last 2 years, I think it is. The JURIST project has really made an incredible effort to engage stakeholders across the region and across sectors. And that's a challenging thing to do. I was just speaking to the Attorney General about, he was mentioning silos, and you know, we all know how important it is to break down those silos and work across them. And I really think that this is an excellent example of how to make that happen. So I'd like to firstly express my appreciation for this initiative under the Government of Canada-supported Judicial Reform and Institutional Strengthening Project, or JURIST as we call it. It's undertaken in collaboration with the Caribbean Court of Justice and the judiciary in the region, and many, many other stakeholders, as I mentioned. JURIST is part of Canada's larger commitment to the Caribbean under a Canadian $600 million regional development program. The program, the overall regional development program, is aimed at building a more prosperous and integrated Caribbean community that is able to generate sustainable economic growth and provide opportunity and security to its citizens. Today's launch of the Model Guidelines for Sexual Offences Cases in the Caribbean represents a significant milestone for Trinidad and Tobago and the region. The Model Guidelines provide internationally accepted best practices for the management of sexual offense cases and offers a rights-based approach to the treatment of complainants and vulnerable witnesses, including children involved in sexual assault cases. It also guides justice sector stakeholders involved in reporting, investigation, prosecution, and adjudication of sexual offenses. These stakeholders include judicial officers, prosecutors, the police, the health and psychosocial care providers from both government and non-governmental organizations. It must be acknowledged that there has been improvements in the local justice system's response to sexual assaults and the survivors of sexual violence who seek redress from the courts. For example, the law in Trinidad and Tobago now places strict limits on the ability of defense attorneys to use the sexual history of the complainant to attack the survivor's credibility. Judges are no longer required to warn the jury about relying on uncorroborated evidence of the complainant, a warning that relied on sexist notions regarding the propensity of women and girls to lie about sexual intercourse. Courts are now empowered to employ special measures such as the use of screens and video conferencing technology to protect vulnerable complainants. And all sexual assault cases involving children are heard in camera. This project and the workshops over the next 2 days are an example of Canada's feminist international assistance policy in action. So we have a new international assistance policy. It was launched in June, and it's actually called a feminist international assistance policy. And I'm really, again, I'm proud to be a part of that, that rather groundbreaking policy from the Government of Canada's perspective. One of the goals of the policy is to strengthen legal systems and promote reforms that eliminate all forms of discrimination against women and girls, boys and men, that prevent them from realizing their economic, political, and social rights. It is particularly timely to launch the guidelines today in Trinidad and Tobago. This is the first day of a week-long series of events and activities geared towards International Women's Day, which is on Thursday, which is celebrated globally on Thursday. And this is a perfect way, as far as I'm concerned, to launch an important week of celebrations. The expectation is that the model guidelines will help to close gaps in the justice system's handling of sexual offenses cases. As any prosecutor will tell you, sexual offense cases are the hardest to prosecute and least likely to produce a successful prosecution. Improved management of sexual offense cases will not only assist the judiciary to effectively respond to the vulnerabilities of complainants and witnesses in sexual assault cases, but will also encourage complainants and witnesses to provide the best quality evidence to the court, while at the same time ensuring adequate safeguards for the rights of defendants. The goal is that all countries in the region will adopt these guidelines, and that implementation will result in a variety of outcomes. These outcomes include speedy adjudication of cases and reduction of case backlogs over time, a more trained and skilled cadre of cross-sectional, sectoral professionals to efficiently respond to sexual assault cases, survivors, and witnesses, and increased public confidence in the justice system as it relates to the handling of sexual assault cases. The Canadian government is gratified to be able to support the people of the Caribbean in developing this groundbreaking document. We congratulate and acknowledge the diligent work of all stakeholders and wish you the very best as you continue to ensure improved access to justice in Trinidad and Tobago and the region. We hope the guidelines will be in every judge's chambers, in each DPP's office, in every police station, healthcare facility, lawyers' offices, community centers, as well as government departments and NGO offices that respond to and provide support to complainants in sexual assault cases. Thank you very much for having me here today, and happy International Women's Day.
Excellency, thank you. Now to give details on the advisory committee, how the guidelines were developed and the next steps, including the implementation of the guidelines, let's welcome the Honourable Madam Justice Maureen Rajnath-Lee.
Thank you, Renee. Her Excellency, Mrs. Rima Carmona, Honourable Chief Justice, Honourable Attorney General, all other distinguished ladies and gentlemen, including those at the head table. And as I look at this side of the room, I feel as if I've come home. My former colleagues from the Judicial of Trinidad and Tobago, a hearty and warm welcome to all, and good morning. I am pleased to announce that we are finally at our last stop of launching these guidelines. We launched in September at CAJO, the Caribbean Association of Judicial Officers Conference in Curacao. In October, we then went to Barbados and Belize. We've been to Guyana and Jamaica. And we did the Eastern Caribbean when we launched in Antigua and Barbuda in January. So I'm not tempted to say we've left the best for last, not at all, because we're the Caribbean Court of Justice and the JURIST project, but we're happy to be here in Trinidad and Tobago to launch these important guidelines. As chair of the advisory committee, it was indeed a pleasure to support the development of this groundbreaking document. The guidelines are the first of its kind in the Caribbean region to put forward a comprehensive, collaborative, and systematic approach to the investigating, prosecution, and adjudication of sexual assault cases. As you have heard, the problems faced by the justice system in its management of sexual offenses and the treatment of complainants are multifaceted and therefore require a multi-sectoral solution. It is for this reason the Sexual Offenses Advisory Committee was established to provide advice and support to the JURIST project in the development of these guidelines. Let me say a few words about the advisory committee. The committee is made up of experts and professionals who have significant experience working with complainants and witnesses at every stage of the justice chain for sexual offenses. They represent a broad cross-section of stakeholders who have a vested interest in improving the management of sexual offenses and are committed to ensuring that survivors of sexual violence receive adequate redress and protection within the justice system. The advisory committee comprises judicial officers from across the region, and let me please give me the privilege of saying, including the Honorable Madam Justice Lambert Peterson, who is present today, and thank you for coming. A criminal psychologist and our own most competent chair, Ms. Renee Cummins. Experts from UN Women, the Faculty of Law, UE Mona, the CARICOM Secretariat, and UNICEF. May I also especially recognize Ms. Gabrielle Henderson from UN Women and a member of the advisory committee. To undertake the task of developing the guidelines, the JURIST project engaged a consultant, Ms. Diana Shaw, attorney at law, a Jamaican by birth, but now living and practicing in Belize. Most of you don't know Diana, so I'm going to ask her to stand, please. A little lady, but she's done wonderful work for us, and I think we could give her a round of applause. In keeping with our, thank you, Diana, in keeping with our multi-sectoral approach, the JURIST project, with the assistance of Ms. Shaw, held regional consultations with justice sector stakeholders in several CARICOM territories and conducted focus group discussions with survivors, persons with disabilities, and persons from indigenous populations. 13 countries participated in 3 sets of regional consultations and 1 national consultation. Each of the 3 regional consultations had multi-sectoral stakeholder representation from 4 countries. Over 100 stakeholder representatives participated in the first round of consultations. The only national consultation was held in Belize in November 2015. The first of the 3 regional consultations was held in Antigua and Barbuda, with stakeholder representation from Antigua and Barbuda, St. Kitts and Nevis, Dominica, and Montserrat. The second was held in Barbados and included representatives from Barbados, Jamaica, St. Lucia, and St. Vincent and the Grenadines. The third was held in Trinidad and Tobago, and stakeholders from Trinidad and Tobago, Guyana, Suriname, and Grenada were present. The methodology for these consultations used participatory approaches to facilitate the collection of qualitative and quantitative data from the country representatives on. And these were the things we were particularly interested in. Existing legislative and policy frameworks in each country, existing institutional mechanisms for the prosecution and adjudication of sexual offense cases, as well as existing support mechanisms for survivors. And you will see that we don't use the term victim. We've taken that out of our guidelines, and we now use the word survivor. Gaps and challenges, we wanted to know what were these in each country as identified by these key stakeholders, and best practices from each country on the prosecution, adjudication of sexual offense cases, as well as existing support mechanisms as identified by participants. Focus group discussions were held with survivors of sexual violence in 4 countries. Survivor representation included men and women from indigenous communities, NGO representatives working with survivors of sexual assaults, including trafficked persons, male survivors of sexual assaults, female survivors of sexual assaults, persons with disabilities who were survivors of sexual assaults, persons who had experienced sexual assault and interacted with law enforcement and the court process as children, persons who had experienced sexual assaults and interacted with law enforcement and the court process as adults. Over 50 survivors and NGO representatives participated. 4 sets of consultations were held, 1 in Belize, 1 in Barbados, 1 in Trinidad and Tobago, and 1 in Guyana. The consultations with survivors used focus groups as well as one-on-one interview methods and adhered to WHO and UN guidelines for research interviews with vulnerable persons. The questions that were utilized had all been pre-approved by the advisory committee. All appropriate consents were obtained and protocols for confidentiality and prevention of re-traumatization were followed. The consultations with the survivors informed the regional model guidelines and also informed the content of the Survivors' Rights Charter, which was also developed under this consultancy. The findings of the regional consultations, as well as the consultations with survivors, provided a comprehensive overview of how sexual offenses are adjudicated in the region. Priority subject areas for the model guidelines were identified. These findings also provided rich data to supplement the desk review, which had been conducted by Ms. Shaw at the beginning of the consultancy, and the 2016 baseline study, which had been commissioned by the JURIST project and undertaken by UN Women. The first draft of the model guidelines was then submitted to a second round of consultations with several stakeholders, including representatives from bar associations of the region and prosecutors from across the region. Their comments and feedback were used to strengthen the document and provide a draft ready for editing. To facilitate and oversee the editing process, the JURIST project convened an editing subcommittee, which I chaired. That subcommittee comprised Justice Adrian Saunders of the CCJ, who sends his regrets he is in court today presiding in a matter. Justice Ian Morley, High Court Judge of the Eastern Caribbean Supreme Court, Ms. Candice Wallace-Henry, former JURIST project coordinator, and Ms. Shaw, the consultant. We are indebted to the editing committee, subcommittee, and especially to Justice Ian Morley for his contribution in streamlining and vetting the document with a view to strengthening both its user-friendly as well as its technical accuracy components. The document you now have, ladies and gentlemen, well, you don't have it yet, but you'll get it soon, is a result of the direct contribution and input of over 200 persons and over 15 months of intensive work. It is robust, it's comprehensive, and it's most applicable to current realities in respect of the adjudication of sexual offense cases in the Caribbean. It is intended by its effective application that it will provide for the best evidence to be obtained in sexual offense cases while minimizing any attendant trauma on complainants and witnesses as a result of their participation in the adjudication process. What are the next steps for this project? Now, of course, we have said before, it is one thing to have a beautiful document, but we want to ensure that it is not only being used by justice sector actors who work with complainants and witnesses in sexual offense cases, but that it will facilitate radical changes in how we, as a region, approach the management of sexual offenses, and in particular, the treatment of survivors. The guidelines, therefore, constitute the first prong of the JURIST project's four-pronged comprehensive approach to the treatment of sexual offense cases. The other three prongs are: 1, building a skilled cadre of professionals, including judges, court personnel, police, doctors, attorneys, NGOs, who are trained to effectively handle sexual violence cases. 2, establishment of a model sexual offenses court in a selected CARICOM country to put into operation the prescriptions set out in the model guidelines. You may have heard, you may be aware, or you may be hearing for the first time that Antigua and Barbuda has been selected as a location for the establishment of the model court. The report from this pilot project will then be shared with other CARICOM countries wishing to implement the guidelines. And thirdly, development and implementation of a regional public education campaign to educate the public on, among other things, the content of the guidelines, the rights of survivors, the meaning of consent, the importance of rehabilitation, and the management of sexual offenders, including child offenders. That sounds like a lot of work, and it was. But in closing, I wish to bring you up to date on the progress of the project in Guyana. In November 2017, we launched these model guidelines in Guyana. At the same time, we were privileged to witness the launch of the first sexual offenses court in the Caribbean. With funding from UNICEF and inspired by JURIST's work on the proper handling of sexual offense cases, the Sexual Offences Court of Guyana was launched in the High Court in Georgetown, Guyana. May I be bold to say that the Guyanese Sexual Offences Court is a tribute to the vision and leadership of the judiciary of Guyana. In addition, we read at the end of 2017 newspaper reports that Jamaica was planning to establish its own sexual offenses court. So I can look across to the left and ask, what's going to happen here? It is intended, ladies and gentlemen, that these specialized courts will enable survivors of sexual offenses to be treated with dignity as they access justice, to have the best evidence obtained in those cases, while ensuring that the trial process remains fair for both defendant and complainant. And there is so much more work to be done in this area. I think we've just scratched the surface. I am happy and privileged, Dr. Reedy, to be part of this project. And I say, let's get to work, ladies and gentlemen, and thank you so much for your kind attention.
Madam Justice, thank you very much. As we get ready for the dance and drama piece by Radical Productions, we're going to ask members of the head table if you would have those seats across there. They want to ensure that you're able to see everything. Ladies and gentlemen, let us welcome Radical Production.
It's okay. You have nothing to worry about.
Don't be scared. No one has to know.
Promise me you won't tell.
No one has to know.
But
shut up!
Be quiet.
Wait.
I love going to the savannah. Mommy and Uncle Ricky carry me there all the time. Uncle Ricky is Mommy's best friend. And when we go to the savannah, we will play games like cricket and football. Sometimes we even play hide and seek. Even though there aren't many places for us to hide in the open field. And after, we will go for ice cream, chocolate ice cream, because chocolate ice cream is my favorite ice cream in the whole wide world. But sometimes, Mommy wouldn't be home. And Uncle Ricky, he would buy ice cream for me. And he would ask me to play a game. And this is a game that we play where he would tell me to touch him. And he would touch me. And he'd tell me to never tell Mommy. Because Mommy boring and she don't like games. But little did he know, I didn't like the games either.
I told her. I told her. I told her that he was touching me. For 10 years, I suffered. And all she would say is, boy, stop being foolish. She thought I was lying or trying to get him in trouble. I wondered if I tell anyone, if they would think that I am less of a man. Laughing behind my back because some man take advantage of me. I wondered if I should just remain silent. Or should I call the police? He tell me, if I tell anyone that he will kill me. I feel so ashamed. The body I once knew was no longer mine, and it became a playground for people like him.
Depression.
Self-harm,
Self-esteem,
guilt,
issues,
shame, blame.
promiscuity.
These are just some of the effects that this abuse has on me, on us. We did not ask for it. We did not wake up one morning looking for it.
And why, after so many years, this abuse has left a deep cut into our lives.
I am ashamed to tell my friends in fear that they would think that I am the next big joke or the next big liar. Speak out!
Let it be known.
We cannot afford to lose others to this crime. Sexual abuse.
Any form of sexual violence like rape, incest, child molestation, or any other form of non-consensual sexual contact.
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 Contact. Let us educate those so that they will know.
Let us pay attention to those around us so that we can detect these kinds of offenses in their life.
Boy,
girl,
young or old, it can happen to any one of us by strangers or by someone we know.
We must do something. Don't let these things go unheard of.
If you know someone who is in need of help, please do all you can do to assist.
It's your business.
It's your business. It is your business. Let's end this cycle of sexual abuse.
Thank you very much, Radical Productions. And now to share with us what a survivor could experience in the criminal justice system and to relate experiences that she has had with survivors, let's welcome Ms. Marian Taylor of the Rape Crisis Society.
Good morning, everybody. All protocols observed. My presentation this morning will focus on two main areas. It will first cite the experiences of survivors of rape who engage in the justice system with particular emphasis on their interaction with the police, medical professionals, and the courts. Secondly, I would explain if and how the model guidelines for sexual offenses cases in the Caribbean region can serve to improve the treatment of survivors of sexual violence in Trinidad and Tobago. Experience with the police. In their experience with the police, survivors cited the length of time taken to bring perpetrators to justice. There were many instances where minors and adults were raped, and after a long time had elapsed, sometimes 3 to 6 months, perpetrators were not charged. At one of our recent sessions, a client reported that she was raped at home. 1 month had passed since a complaint was made, and the police had yet to return to gather evidence, and even though they gave assurances that this would have been so. Delays experienced in their quest for justice also ensure that complainants and their families are sent to different police stations before police reports were actually taken. Thereafter, the investigating officers seem to disappear. Efforts to contact them for information proved futile. Consequently, frustrations got the better of some complainants, and they chose not to continue their matters. Survivors need closure, which should be done in a timely manner to help them recover from traumatic experiences and develop trust in the justice system. Some female survivors have shared that they perceived male police officers to be quite insensitive into their plight during interviews. They stated that some officers refused to believe that they were sexually violated and had no support is rendered during the time statements are being given. They indicated the preference to be interviewed by female officers. Survivors also claim that they received no support from the police while given statements, and at times they felt like criminals because of the treatment meted out to them. I would now go to the experience with medical professionals. Female survivors have reported that male doctors examined them after experiencing vicious rape attacks. Not only did they experience flashbacks of the ordeal, but also the doctors were not sensitive to their trauma. They lacked gentleness and compassion while gathering the evidence. Survivors who were minors at the time they were raped and as a result became pregnant reported instances of victimization by attending nurses during delivery. Those nurses operated on the assumption that the minors who were reluctant to disclose the genesis of their pregnancies were involved in voluntary sexual relationships. Experience with the courts. Survivors explain that cases often take a very long time before being heard in court, and after a long period of time, they felt victimized for a second time when called upon to give evidence. They mentioned that the lawyers for the defense asked questions which were designed to humiliate them and degrade their character in the presence of families and friends. At the conclusion of a trial, even though the perpetrators were severely punished, they still felt worthless, re-victimized, and afraid to face society. Because of this experience, most survivors swore never to pursue justice if they were the subject of rape again. They have inquired about giving evidence via video link. They stated that guidance was sought from the police on this issue. However, none of our clients for the years 2016 to 2017 have reported the use of video link. Our clients are of the view that the courts have failed to take into account their safety when considering whether to grant bail to perpetrators. In many cases, the granting of bail were not communicated to complainants, and there were regular instances of re-traumatization when they faced their attackers in the community. Now, the question now arises, how can the guidelines improve the treatment of survivors of sexual violence? The experiences of our survivors have revealed 5 issues in the chain of justice. They are timeless, sensitivity to the plight of survivors, lack of support system, disregard for the safety of complainants when granting bail, and traumatization of victims by defense lawyers during trials. The guidelines have addressed the issue of timelessness for each process in the judicial train by allowing the court to set timelines for completion of judicial tasks. The Bailey's model outlined on page 28, which you will soon have in the document, Judicial Reform and Institutional Strengthening JURIST project is quite instructive. If properly tailored for Trinidad and Tobago, our police and court services can certainly be reformed, resulting in swift justice. The court-appointed supporters are an excellent initiative that can assist survivors in understanding the process. There is a lack of trust in the police, hence interacting with someone who acts in their best interests can serve to prevent survivors from being re-victimized. Procedures outlined for the granting of bail will ensure that complainants and witnesses are protected from re-victimization and harm. The guidelines that are set for cross-examination and the making of summations have addressed the issue of secondary victimization during trials. While cross-examination, complainants, defense lawyers will not be able to ask questions about their previous sexual history or questions designed to raise irrelevant scandal and cause embarrassment. The stereotyping of complaints during summations is also prohibited. Further, unrepresented defendants will not be allowed to question complainants, but a lawyer will be able to appoint to do so on their behalf. The foregoing provisions will certainly serve to improve the treatment of the survivors of sexual violence. It is therefore the view of the Rape Crisis Society of Trinidad and Tobago that the guidelines, if implemented, with the responsibility for all actors within the criminal justice system to account for their actions, then the aim to reduce secondary victimization that survivors experience when they seek redress from our justice system will be achieved. At this point, let me just put a little plug for the Rape Crisis Society. We are hoping to embark on supporting survivors while they have trials going on, whereby they would be able to come in for counseling. So that will be an additional form of support. I thank you, ladies and gentlemen.
Marion, thank you very much. And now to tell us about government's work related to addressing sexual violence in the justice system and how the guidelines complement government's work, let me welcome the Honorable Faris Alwari, our Attorney General. Thank you.
Your Excellency, Mrs. Carmona, First Lady of Trinidad and Tobago, the Honorable Chief Justice, Mr. Ivor Archie, distinguished members of the head table, distinguished members of the audience, good morning to you all, with all protocols having been observed. I'm obliged this morning to exercise restraint, a microphone, a politician, and an audience. Sometimes it can convince one to actually take advantage of a situation, but I promise you that I don't intend to do that. Ladies and gentlemen, this is a very momentous week for Trinidad and Tobago. Not only because of the launch of the work product before us this morning, but this week we will also be opening our Family and Children Division. We will be launching the 2 courts, firstly in Port of Spain and secondly at Faizabad. And we will, during the course of this week, also see certain bills headed to the Parliament which improve the work product. Madam Justice Rajnath Lee put out the concept of a blueprint sitting on the very many desks that sit in this room, be it the judiciary's desk, the law enforcement desk, the prosecutor's desk, or the executive's desk. And I'm very pleased this morning to speak to the coincidence of work that the government of Trinidad and Tobago has in relation to this work product and launched this morning. The guidelines are only as useful as the articulating system to make them work prevail. After all, we do have, in the body of laws in Trinidad and Tobago, quite a lot of what we need. We have preliminary inquiries, we have plea bargaining, we have DNA, we have Sexual Offences Act, we have the Supreme Court of Judicature Act, we have the Criminal Proceedings Rules now, we have the Civil Proceedings Rules, we have the Family Court Rules. But justice in terms of a survivor's right, justice in terms of an innocent person's right, that one being a rather ticklish one, he who is alleged to have committed a crime but has not. Justice from a society's point of view. Justice seems to have escaped Trinidad and Tobago for a very long time. It is a reality that our system takes a very long time to go to work. And therefore, an executive has the function of putting the pieces together. Putting the pieces together is not as simple as paying for it. Putting the pieces together requires an executive mind to firstly understand the scope of the issue, secondly, to manage the buy-in of the many participants in the process of justice, thirdly, to ameliorate and amend the laws if necessary or to come up with different packages, fourthly, to undertake value for money financing in terms of the provision of services. And what I can say is that that blueprint, which is such an excellent product before us this morning, being launched, having gone through the tour of jurisdictions with perhaps the best for last, even though Madam Justice Rajnathi didn't say so, forgive me for saying it, that requires a commitment. And commitment is born on the back of hope. Because if one doesn't have hope that something can be achieved, then we're really walking in a circle without any form of direction. So the takeaway from the particular document, which is going to be distributed shortly, resides around court processes, and secondly, around survivor or victim impact and management. Those are the two core areas from the document, which is now a blueprint across the many desks spoken of. And I am able to say with certainty that the process in parts 2 and 3, as you'll see them, the process of the delivery of justice, the process of dealing with sexual offenses cases requires a system to actually work. Our government, upon entry into office, engaged in situational analysis. Trinidad and Tobago was given, for the first time in its history, a true reflection of who we are and what we are dealing with, the good, the bad, and the ugly. Now, each one of us know with certainty what our arrears of preliminary inquiry cases looks like. It's 29,000 odd cases. We know that our motor vehicle and road traffic offenses have crossed over 100,000. We know that our judiciary has been literally working miracles on a shoestring budget. We know that our Trinidad and Tobago police service have been overtaken by immense amount of work in terms of distribution and management of assets. We've watched the Children's Authority, as I recognize the chairman here with us this morning, Dr. Benjamin. We've watched the Children's Authority come into center point. The situational analysis told us that we have DNA laws since the year 2000, but we don't actively use it. We've got plea bargaining laws, and we've had that since the year 1999, but we actually don't have anything more than a few examples of plea bargaining successfully done. It shows us that we have managed our children's arena in a rather curious way. So we went to work, ladies and gentlemen, and we have brought to life, firstly, the Family and Children Division, which we'll speak a lot about tomorrow. And I wish to pay the most fulsome compliment to the Honorable Chief Justice of Trinidad and Tobago, Mr. Justice Ivor Archie, for driving home a first-of-its-kind forum where this work can go to work. The Family and Children Division involved the passage of novel law. It involved 19 amendments to other laws, 19 pieces of law. It involved the expansion of the judiciary. It involved the creation of 2 standalone courts in Port of Spain and in Faizabad. It involved the interview of 13,000 people for the respective positions. It involved the TTPS having a child protection unit of 169 people. It involved the Children's Authority coming to life. It involved the creation of child rehabilitation centers and children's homes. It involved the UN protocols for the coordination. It involved the launch of the family proceedings rules, the family and children proceedings rules. It involved the guidelines. It involved the launch of the ability to pay online and for electronic payments, which will come live on Friday. And that, ladies and gentlemen, was done in 18 months flat. And that's a first for Trinidad and Tobago. That involved an indigenous information technology system so that our magistracy can actually have data managed on a real-time basis, brought home by no less a person than the Chief Justice on a trip to Nigeria, and then bettering the product by the work of the government of Spain at a cost of a few cents, relatively speaking, against the dollar. And I wish to compliment the Honorable Chief Justice for being the engine of work in this product and for allowing the government to do the work which we did to make sure that that happened. Because I had the pleasure of piloting all of the legislative reforms and sitting for umpteen hours, day on day, night on night, to get the laws in gear with the operational structures. In bettering the processes for this work product to go to work, we have also ensured that we're about to replicate a criminal division. And that criminal division, Madam Justice Rajnath Lee, is one which will see the marriage of the summary jurisdiction with the High Court jurisdiction, allowing for a fluidity of case transfer. That jurisdiction will allow us to create in Trinidad and Tobago our own sexual offences courts. We have also been very pleased to operationalize our DNA laws and the regulations to bring DNA to life will be in the Parliament on Friday. But we didn't stop with the regulations. For sexual offences, you need to make sure that the weight of evidence is as quickly managed. And when you have something such as DNA with a 99.8% reflection as to evidence at least, you're narrowing the gap. You're inviting people to adopt plea bargaining because you're facing a strong consequence. And so the government has taken every single sexual offense matter, listed it, and called for the DNA profiling against it. And I'm very pleased to say that we've not only appointed a custodian, we've not only outfitted the position, but we have 15,000 DNA kits en route to Trinidad and Tobago to begin the DNA data bank. And that DNA data bank will comprise all sexual offenders, all persons accused, and against the profiles of persons who are in the system. Because that system involves making sure that the TTPS is on the bank, the prison service is on the bank, the forensic experts is on the bank, so that we have an opportunity for the first time in our country to bring to life DNA legislation and put it to work in courts in a specialized environment. And I want you to understand the hope of that. But what have we done further? We took a note of the observations made in the debates on the abolition of preliminary inquiries, an experiment which we've been speaking about for only 26 years now. Our country has been talking about the abolition of preliminary inquiries. And what I can say, as I see Justice Mohammed here, who actually authored and signed off on the 2008 reports for the abolition of preliminary inquiries, and looking at the many persons here whom I've read so much of and the work that has been put upon administration after administration, in whatever capacity, be it the judiciary or successive executives. That work for the preliminary inquiry abolition is certainly returning to the Parliament of Trinidad and Tobago for completion, and we expect to do that, all fingers crossed, by the month of March as we see it. But in treating with that, we recognized that the system of justice, the rollout of sexual offenses, can only happen if your system is moving. So our Family and Children Division sees the addition of 13 judges across the bank. Further, we have analyzed the position as it relates to counsel, because your counsel of choice results in a system where your defendant is not able to proceed in matters because counsel is unavailable. And I'm very pleased to announce today from this platform that our public defender system has been completely mapped out, with the additional bodies mapped out, the spatial requirements mapped out, and it does not involve an act of Parliament. It is an administrative restructuring of the legal aid authority to allow for competent counsel to be appointed in cases. Obviously, there'll be some fine-tuning in terms of the judiciary's direction after how many occasions one ought to receive a public defender as opposed to counsel of choice. We've gone further. In looking at this particular system, as I recognize the very hard-working Commissioner of Police, Commissioner Williams has sat together with the Director of Public Prosecutions and the Office of the Attorney General, and we are mapping forward our National Prosecution Agency, which is ultimately, in a best-case scenario, a combination of how one manages the prosecutorial services provided by the Trinidad and Tobago Police Service, who conduct 95% of our prosecutions, with the Director of Public Prosecutions offices, which conduct about 5%. And the whole issue of the prioritization of sexual offenses in the more serious crimes of murder, etc., therefore comes to life. This is very much a whole of situation perspective, and I ask you to support, by way of public advocacy, the maneuvers that we're making in this regard. Ladies and gentlemen, we also have on deck, on the laws of Trinidad and Tobago, our judge-only situation. And I ask you to note in particular something which we're doing in the judge-only arena. The commentary coming in the Parliament as to the viability of judge-only was that who would choose a judge-only? I'd like to tell you from the work that we're doing with children, with people used to be called inmates, lads or ladies at YTC, be it on the boys or girls side, now properly referred to as child rehabilitation centers at law. I wish to tell you that that pot of issues is something which is very forefront and center in the government's perspective. And what I can say is that the ability to have those cases managed in a judge-only environment becomes a very real one. I can tell you that in the conversations I have had personally with the inmates at the CRCs, many of them often say to us, thank you for the option for judge-only, because I, having committed or on trial for an offense committed whilst I was a child, think that I ought to fare a better chance before a judge who will have the ability to see me as that child who committed that offense, as opposed to the quote-unquote hardback man standing before a jury. And that is why we were so passionate about providing the opportunity for judge-only environment. We have, and I know time is limited, and I did promise to keep it short, we have on the second limb, which is the survivor or victim positioning, two very important work products that I'd like to just point out as we tie the pieces together. The first one is in relation to something I've touched already, which is the plea bargaining laws, which we have repealed and replaced, and which we will proclaim shortly. And that focuses very squarely upon victim impact statements and the ability, in particular in the sexual offenses arena, to have the victim, the child victim, forgive me, I'm using the term from law as opposed to the suggested term of survivor, but the term in law is the victim in the victim impact scenario. We have on deck the opportunity for the factoring of the victim impact statement, of course in a due process context where the judge has ultimately the ability to ensure what is actually communicated in these trials. And that plea bargaining in this new and improved structure of treating with all of the elements, the judges, the prosecutors, the defense attorneys, the rules of court, the operationalization of system, the physical outlay, that plea bargaining in terms of a victim or a survivor issue becomes a very real instrument of bringing to life the work product that we're launching this morning. The second one is something which we are nearly completed with, and this one I consider to be revolutionary. We are settled, at least from the Attorney General's office, upon improvements to the Evidence Act, and in particular to the use of specialist arrangements for victims or for survivors. And that involves anonymous evidence, that involves special arrangements, because it's one thing to talk about the use of video linkages, as we just heard from the Rape Crisis Center, but it's another thing to have it as a characteristic feature of your laws. Obviously, we can't do it unless our laws are amended to treat with this product. And I wish to be an advocate for support of the amendments that we propose in respect of the evidence arrangements in Trinidad and Tobago. It is multidimensional. It doesn't apply only to children. It applies to terrorism. It applies to gang violence. It applies to any area where there is a potential for victimization or prejudice to witnesses. And it is something which our courts and which our jurisprudence have reflected upon and have called for a very long time. I'll borrow the expression that the Honorable Chief Justice has used on so many occasions. It's just common sense, ladies and gentlemen, that we encourage these amendments and see them brought to life. I'd like to touch on one last issue, which is really the trafficking in persons mission. At the Attorney General's office, we have created a task force to treat with trafficking in persons. We have done a significant amount of work with all of the operational entities at the Ministry of National Security, at the Prison Service, at Witness Protection Program, Ministry of Education, Ministry of Health, Children's Authority. And that trafficking in persons arrangement becomes a very real phenomenon, particularly when we look at the situation of immigration, undocumented immigration, and passages between South America and Trinidad and Tobago right now. And therefore, there has been the creation of a very careful arrangement of task force operation, which is why, ladies and gentlemen, Trinidad and Tobago has, as a jurisdiction, gone up in the trafficking in persons reports in terms of positive reflections done by the United States of America's government. And that wasn't by mistake, obviously. It was with careful operation and planning. I wish to commend the work product before us this morning. I wish to commend the blueprinting of this formula for reflection. It is comprehensive. It has been the product of very many excellent minds. It is a work product produced in similar nature to those who have worked on so much of our family and children division work. Madam Justice Armorer mentioned a little while ago when I was having a small chat with her the reminder about the family court. I'm very pleased to inform that in San Fernando, which I have the pleasure of representing as Member of Parliament for San Fernando West, that property which we purchased from the Clooney in 2009 is finally going to be utilized. And I wish to thank again the judiciary of Trinidad and Tobago and the Chief Justice for ensuring that that work product happens. We're mapping out the arrangements now. And again, it's not often we get the Chief Justice here, so I'll give him another compliment, if you permit me, because we are in an effort between the Ministry of National Security, the Attorney General's office, and the judiciary. We're settling the in-house planning arrangements for the building of a full court at maximum security prison. We expect to open our video conferencing facility shortly, but we're going a step further, which is to put in a full court at MSP. Why? Again, it's not only common sense, but it's value for money. We spend $80 million a year in transporting prisoners up and down Trinidad and Tobago. And I'm very pleased to say that the judiciary already drafted the plans for the court. The Ministry of Works and Transport in-house division is settling upon the final arrangements, and we will see that court built in very short measure. Ladies and gentlemen, we have a phenomenal product. As I interrupted myself in thanking those who prepared it, permit me to return to that as I wrap up. Thank you to the Caribbean Court of Justice. Thank you to the Government of Canada that has stood side by side with Trinidad and Tobago, not only on this work, but also on our criminal justice advisory work that you footed the bill for a very long time. Regrettably, there wasn't much movement prior to certain people coming on the scene, but we thank you for your continued support. Your Excellency, you put your money where your mouth is. So it's a very rare thing in today's world to see that phenomenon, and Trinidad and Tobago thanks you from the bottom of our hearts for the support that you have given to us as a jurisdiction. To the many persons in attendance this morning, thank you for permitting a politician to stand before a mic with no paper to give you some of the reflections about making the whole proposal a reality as opposed to just a blueprint. I thank you sincerely for your attention and for your patience.
Attorney General, thank you very much. And now the Honorable Chief Justice on why the judiciary is supporting the guidelines.
Thank you, Madam Chair. What the Attorney General neglected to mention is that he also falls into another category of people whose estimations of time are notoriously unreliable, and that he's a lawyer. You know? But I'm very grateful to him for his very kind words. And permit me, please, to go through the list of salutations, and there's a reason why. I would wish to acknowledge, first of all, Her Excellency, Mrs. Rima Carmona, our First Lady, not least because Mrs. Carmona and our beloved President have, throughout their tenure, exhibited a commitment to the welfare of the youth of our nation. And so, ma'am, we're very grateful to have you here this morning. I acknowledge as well the Honorable Attorney General, the Minister of Gender Affairs and Child Development, the Honorable Ayanna Webster Roy, Her Excellency Carla Hogan-Rufels, High Commissioner of Canada to Trinidad and Tobago, of course my esteemed colleagues of the Appeal Court, High Court Masters and Magistracy, Dr. Carrington, Secretary of Health, Wellness and Family Development of the THA, I see Chairman of the Commissions and Mr. Williams, Acting Commissioner of Police, Dr. Reedy, of course, Madam Justice Rajnath Lee, Ms. Marian Taylor from the Rape Crisis Center, Ms. Renee Cummings, Mr. Benjamin from the Children's Authority, members of the media, distinguished ladies and gentlemen all. I want to mention everybody because the work product that is being presented this morning and the initiatives that you have heard the Honorable Attorney General speak about could not have taken place without the presence and participation and active support of everybody whom I have acknowledged, whether personally or through representatives of their respective organizations or offices. And for me, I continue to carry a deep sense of gratitude for the work, the hard work that is so often put in unseen from the persons who are very enlightened in their approach to criminal justice, who sat without reward unheralded, because I know, because I've spent many a weekend and public holiday with them as we developed judges' rules for children and all of the various statutory and rule underpinnings that have brought us to where we are today. As you know, my philosophy has always been that while the judiciary must continue to exercise its role independently, we cannot do so without the partnership, assistance, cooperation, and continuing conversations with all the other arms, organs of state, as well as non-governmental organizations who continue to contribute towards the welfare of our nation and particularly our children. My task this morning, as has been mentioned, really is to really share with you some insights into the reasons for the judiciary's enthusiastic support for these model sexual guidelines. It's a little difficult coming at the end of the batting order to say anything that hasn't been said already. But I will try my best to just wrap up and just remind us why we are here. As many of you, I'm sure, are aware, sexual offenses are among the hardest offenses to successfully prosecute. As a result, most of them never come to the attention of the criminal justice system. And let me pause here to thank the members of the two young persons who presented that really, really powerful piece, because they were able, I think, to capture so much of why that is so, and present it in a very impactful and graphic way. Most offenses never come to the attention of the criminal justice system, and an insufficient number of them, when they are reported, actually result in criminal proceedings being initiated. And this is so partly because reporting rape or any sexual offense is re-traumatizing and is a significant deterrent for survivors. But it's also because of the historical structure of the justice system, the fact that lengthy court processes are difficult for survivors to endure. And if only for those reasons, sexual offenses should be given priority. Prosecuting sexual offense matters takes on average more than 2 years from the date of the offense to the date the court trial begins. And awaiting a court date for the hearing is usually an emotional roller coaster for the survivor. Historically, as we've heard, victims of sexual assault have often been terrified of reporting their experiences because of how insensitively cases are addressed and the slow pace at which investigations are done. But happily, we are beginning to see a more enlightened approach, of which these guidelines are but one example. When the matters do reach court, survivors are reluctant to continue because of how long it takes and how traumatizing the recounting of the experience can be. The sad truth is that anyone, women, men, children, babies, irrespective of gender, can be a victim of sexual violence. It is not their fault that it happened. And all criminal justice actors, be they police, prosecutors, magistrates, judges, court clerks, medical personnel, must deal with all reported sexual crimes without discriminating or making assumptions about victims because of race, nationality, religion, sex, age, sexual orientation, or for any other reason. We have seen over the recent years much progress in the region on the promotion of gender equality. However, the issue of sexual violence perpetrated against women, girls, and boys does remain a significant problem. we continue to experience high levels of sexual violence, the majority of which, as I've indicated, is either underreported or unfortunately ineffectively dealt with by the justice system. There has been, however, a continuous push to improve our response to sexual assault and to the survivors of sexual violence who seek redress from the courts. And so it is in this vein that the judiciary of Trinidad and Tobago, like many of our Caribbean neighbors, being aware of the difficulties experienced by vulnerable persons, whether as survivors or witnesses, has been working with the JURIST project to develop these guidelines as a means to improve public confidence in the justice system, so far as it relates to the handling of these types of cases and treating with vulnerable persons in a fair and unbiased manner, so that there is a willingness to engage with and participate. We are anxious to ensure as well that all parties are on equal footing so that there can be no claim of bias on the part of the judicial officer if he or she is acting within the purview of the guidelines. And so the guidelines which you will see being launched here today will be used as a tool by magistrates, judges, police officers, court clerks, attorneys, to better respond to the sexual assault cases and to witnesses and survivors, ensuring that vulnerable persons receive the necessary support to give the best quality of evidence, while also ensuring adequate safeguards for the rights of defendants. It bears repeating that by their very nature, sexual assaults cause trauma not only to the survivors. The damage extends to varying family members and community dynamics. And the justice system must therefore reflect an awareness of all of these issues so as to better equip itself to handle cases of this nature. We in the judiciary must ever be mindful that the survivor of a sexual assault has suffered a serious violation of his or her fundamental rights. His or her sense of dignity has been shattered, and his sense of safety is affected, and may result in them not wanting to cooperate with authorities or with court proceedings. And so we have to ensure that the proper protective measures are in place for the victims. In instances where the perpetrator of the crime is a family member, the court is required to ensure that there's provision of alternative support and rehabilitative services, especially if the witness remains in a vulnerable position, whether by reason of age, relationship to the perpetrator, or by reason of any other personal characteristic. The court must encourage survivors to fully participate in court proceedings, being mindful that there should be minimal re-victimization. So how are we to achieve this, given the nature of the matters? The courts will maintain, and I'll just mention a few of the guiding principles that are provided for as the foundation of the guidelines. We are to ensure that the rights of all complainants and defendants will be protected, and all service delivery will respect their rights and dignity. We are to ensure that all court services will be provided in a non-judgmental way that facilitates the empowerment of complainants. We are to try to ensure wherever possible that specialized training is an essential part of ensuring that the best evidence is collected. Service delivery must not re-victimize the complainant or traumatize witnesses, and vulnerable complainants or witnesses will receive specialized support services. Service delivery will recognize that due to the traumatic and disruptive nature of sexual assaults, support services will be needed, and this may require multidisciplinary collaboration with other agencies. And of course, at all times, the confidentiality and privacy of survivors will have to be respected and protected. Our main role and function, therefore, is to ensure that all that is required to be done before a matter commences, trial is done, and that there are specific guidelines to assist pre-trial, during the trial, the progress and speedy completion of matters. In that regard, the judicial officer's role is somewhat more inquisitorial than historically envisaged at the pretrial stage, in ascertaining whether what is supposed to be done is in fact done, issuing the necessary directions to resolve matters at the first hearing, such as issues of disclosure, and making sure that trial dates can be given in a timely manner and the matters are not unduly prolonged. Courts will have to ensure that accused persons are brought to court within a reasonable time and as required by law, determine issues of bail, inquire about the safety of the complainant. For example, if the defendant is a child, the court would have to ensure that he or she is properly housed. Guidelines enhance really what we have been trying to some extent to achieve. And they ensure that by adhering to them, we are kept mindful of the appropriate guiding principles. In order to achieve our objective, it means that other external agencies such as the police, prosecutors, medical personnel also have a major role to play, as they will interface with the survivors and/or defendants before they appear before us in court. They are therefore required also to properly prepare cases for court while protecting the rights of the victim and not infringing the rights of the defendants. Once that is achieved, then the court is called upon to ensure that cases move through the process without undue delay, since long delays will usually result in re-traumatization of the complainants, whose healing and recovery is set back by having to revisit traumatic details of the assault. It's important because delay often leads to survivors losing faith in the court process and therefore refusing to participate, with the result that offenders are often not brought to justice. And so the advantages of the guideline that with its implementation, from the time of arrest to trial, there should be, 1, a reduction in the length of time that a sexual offense matter takes before it is adjudicated. 2, a reduced number of adjournments. 3, a reform of the police investigative practices. 4, reform of the court listing practices, including greater certainty of trial dates. 5, the recovery process for survivors should be enhanced and made quicker. 6, there should be active case management of all proceedings. 7, directions on all aspects before and during trial. So, for example, we will have to sit and determine beforehand what sort of questions will or will not be allowed in respect of vulnerable witnesses or survivors. And of course, and at every stage, the applications and directions will have to be sought from the court. And so these guidelines, together with the Criminal Procedure Rules 2016, will, in my respectful view, significantly improve the manner in which the judiciary deals with sexual offense cases. It is hoped that more victims or survivors will feel safe to come forward with their reports, as they can be assured that they will be treated in a way that will respect their dignity and their privacy, as the necessary support will be assured, whether it will be by the use of specialized measures, such as video links or screens, the presence of persons to provide support, or the imposition of conditions, such as restricted contact, which of course is already a feature of our criminal justice system. The guidelines, you should be aware, encompass internationally accepted best practices for the management of sexual assault cases, and they promote a rights-based approach for the treatment of complaints and in dealing with vulnerable victims and witnesses. I am confident that the implementation of these guidelines, survivors of sexual violence will receive improved substantive justice. I have no doubt that as we move towards the formalization of a sexual offenses court, it will make a positive contribution to the development of the judiciary and result in the speedy adjudication of cases and the reduction of case backlogs over time, the improved responses to survivors that will enable their full participation in the justice system. It will increase offender accountability and reduce secondary victimization, as well as facilitate, as you would have heard, the development of a trained and skilled cadre of cross-sectional professionals, including judges, court personnel, police, and attorneys at law, who will efficiently respond to reports of sexual assault to survivors and witnesses. For my own part, I have to say that I have been educated during the course of this journey. I, for example, only learned a couple of years ago that there is a subspecialty that exists called forensic gynecology. I didn't know that when we began this journey, and I think some reference was made, you know, to the experiences of survivors who are examined by medical personnel who may be not only insensitive to the psychological trauma, but as well don't even know what to look for. So that as we develop these capabilities and these expertise, both the experience of the survivors and the quality of the evidence gathered and presented in court will improve. And we as a national community must, of course, devote our limited resources in a more focused way to better serve our clients. In closing, I wish to extend particular appreciation and congratulations to the government and people of Canada, who have been really steadfast and consistent in the support of this and many other local and regional initiatives. You know, the JURIST project was a bold and innovative step when it was first conceived, because, you know, previously foreign assistance was government to government, and it was the government of Canada which first took the bold step to engage directly with judiciaries in the region under the chairmanship of the Caribbean Court of Justice, represented here by Madam Justice Rajnath Lee, to directly impact improvement of the administration of justice across the region. And I must say that it has been a tremendous success and a source of great, for me, a source of great pride and gratification. And I want to say thank you as well. I acknowledge Dr. Reedy as well, who has, since she has come on board, has breathed life as well into the project. And so I want to thank the JURIST project members as well, and the committee members who have worked tirelessly to make these model guidelines for sexual offense cases a reality. We will continue, I pledge, to play our part in ensuring that justice is done to and for all. Thank you very much for the courtesy of your attention.
Honorable Chief Justice, thank you very much. And now we are going to present the model guidelines. We will begin with a presentation by the High Commissioner, Excellency Carla Hogan Rufield, who is going to present it to Her Excellency Rima Kamuna. And now let me invite the Honorable Madam Justice Maureen Rajnath Lee, who is going to present it to the Honorable Chief Justice, Mr. Ivor Archie. And let me invite the High Commissioner one more time, who is, that's going to be more than one actually, the High Commissioner again, and she's going to present it to the Honorable Attorney General, Mr. Faris Alwari. High Commissioner, I'm going to ask you to stay to make this presentation to the Acting Commissioner of Police, Mr. Stephen Williams. And now Dr. Penny Reedy, the director of the JURIST project, and she is going to present it to the Rape Crisis Center, Miss Marion Taylor. Thank you very much, and just to let you know, we will all get a copy at the end of this morning's formal launch. And let me just remind you, if you've RSVP'd for the sensitization workshop, that workshop will begin at 1:15 in this room. And for those of you who did not RSVP for the workshop, we would still like you to attend, so speak to Anika Gray. She's in red, and she wants you to stay, as well as lunch is going to be in Regency 5. Ladies and gentlemen, thank you very much, and have a wonderful rest of your morning. I'm Renee Cummings, and it was certainly a pleasure.